2623545. My only concern are, because it's a harassment case, are there any conditions that we should place? Do you mind, I guess, reading what
The
happened?
probable cause actually, I'd like you to look at that.
Sure,
So he's
of course.
present, but it's.
I know, yeah, but it's okay.
Harassment statute.
Law enforcement were dispatched to a public roadway in reference to a vehicle disturbance. Complainant advised defendant followed her to her residence and threatened her following a road rage incident. She advised she was stopped in the intersection at a red light. Defendant honked immediately when the light turned green. Complainant advised she made a left turn onto the bender. Defendant was behind her and made a left turn. Defendant attempted to go around her, but was unsuccessful due to traffic. She advised defendant followed her to her apartment complex. Defendant appeared to reach into his backseat for something, took photos of complainant with his phone. Defendant circled the parking lot yelling, "I know where you live, I'll be back later." Then yelled racial slurs. Complainant feared for her safety and believed defendant would return. Complainant followed defendant to Planet 4 to get a better description of his license plate. Provided license plate to dispatch. They initiated a traffic stop on the defendant's vehicle for failure to signal lane change. He advised he was in a road rage incident where complainant brake checked him several times after he blew the horn at her. Defendant advised complainant followed him to Planet 4, denied following her to the apartment complex. Defendant advised he wasn't going to harm her, he just blocked her on social media. Complainant provided recording of the interaction, which shows defendant circling the parking lot of the apartment complex, yelling, "F you, cracker." The light just turned green. Defendant responded, "I know where you park now. I'll be back later. I'll be back later. You better watch yourself." And yelling racial slurs and drive off.
General argument, the racial slur is this white guy called the other person a cracker allegedly.
Well,
But-
let's pull the statute.
Planet 4 is literally right next to the apartment complex, my side is driving, so he took a picture of her plate, she followed her, took a picture of his plate. That was the harassment, I mean, it's just too big, stupid, it's what we see on the news all day long. I think it's
Whoa.
Grizzlies, good news and stuff.
But so harassment occurs when an individual with the intent to harass, annoy, alarm, abuse, torment, or embarrass another engages in specific prohibited communications.
So they're not prohibited communications. It's not, I mean, it doesn't track as no.
Well,
But you're telling me it's every person that might have this courtroom, including the DA's office, would be in jail today for harassment based on.
I think that I would perhaps agree with you, but for the fact that they're saying it goes to the actual house.
The house is 5 minutes from he went because he was getting a vehicle service, he was dropping to a vehicle service. And it's clear. I know you don't know that. I mean, that'll be a drop down the road when it gets there, but I mean, I don't.
Yeah, I think that, so I think that there's enough for probable cause purposes. The only thing I'm gonna order now, and what I can do is I can give you the conditions,
Okay.
have him sign it, get it back to us by tomorrow,
Yes.
and then, we'll set it for next week, whatever day you want, but in the interim, he needs to know that he's not to have communication with her, no weapons, no going to her house. If you can file those, I'll print it out, I'll give it to you. I'm gonna find PC, but pick a day, whatever, next week. He'll come, we'll just have him sign everything and then we'll, yeah. So pick whatever day you want next week. Just before you leave, let us give you the conditions. He's got to have it signed back to us tomorrow.
Yes, sir.
And you can just file it,
Will he file
sure.
it? I did.
Okay,
Just to make sure, no contact with the complainant, no returning to her address, no firearms.
right. No going to her work, place of, where she lives, just no contact whatsoever.
Yes,
Yeah.
Thank you, sir.
Okay, thanks, man. We are here in cause number 2610376, State of Texas versus Luke Therio. We are here because Mr. Therio is wanted out of Calcasieu Parish, Louisiana. There is a fugitive warrant that was issued back in 2022, if I'm not mistaken. Guys, would you announce yourselves for purposes of the record, please?
Dave Kim for state.
Haley Alfaro for defendant.
The reason we are here is for purposes of the record, it appears that in Mr. Theriot's case, he was picked up mid-March, went before a magistrate March 16th of 2026. And at that time, he had the ability to either waive extradition or refuse extradition. And it's apparent here that he at that time refused extradition. For purposes of the record, also, he's wanted for cyber stalking, violation of constitutional rights, among other things. A governor's warrant has been obtained in this case. It also appears that an application for writ of habeas corpus was filed yesterday, 6/9 of 2026.
Yes,
State,
Your
would you like
Honor.
to proceed?
At this time, I'd like to introduce the governor's warrant. A copy has been tendered onto council, along with an order securing fugitive after service of a governor's warrant.
Okay. So it looks like you have obtained the governor's warrant.
Yes, Your Honor. And a state is waiving notice requirements for the writ of habeas corpus. State is ready to stand, opposed to the writ.
Okay.
So for the governor's warrant, he is wanted out of Calcasieu Parish for 2 charges: false statement concerning denial of constitutional rights under warrant number LCPD 2024-010163, and cyber stalking under LCPD 2022-005784. The data incidents were October 25th, 2022 and June 10th, 2022, respectively. And the warrant was signed on November 9th, 2022 and November 1st, 2022. In the defendant's application for the writ of habeas corpus, it only alleges one violation, that the papers are not in order, and only cites one affidavit where it states that the date is inconsistent with when the warrant was signed in 2022, because the affidavit notes that it was from August 2024. However, that discrepancy is actually a lexical ambiguity. The second warrant for the false statement concerning denial of constitutional rights, while the warrant was signed by the 14th District Court in Louisiana, it wasn't entered into NCIC until August 2024. And so it is not incorrect. It was just addressing a different part of the warrant process. For the governor's warrant, it has shown to fulfill all the other requirements, and under Coester 450 Southwest 3D 908 is that once the governor's warrant regular on its face is introduced into evidence, the burden shifts to the accused to show the warrant was not illegally issued, was not based on proper authority, or contains inaccurate recitals. However, they may not complain about any of the papers which have not been offered. This stems from when he was originally arrested in March 16th, 2026. A governor's warrant was issued out, or a petition was issued out from the state of Louisiana's DA's office on March 20, 2026. The sworn statement from Detective Russell in Louisiana was signed on April 1st, 2026. It was sent to the state of Louisiana Department of Justice, to the Attorney General, Liz Murrell, and a governor's warrant packet was requested for the Louisiana governor, Jeff Landry. The Louisiana governor signed the governor's warrant on May.
Okay, pause. This just got way more complicated. We've shifted from road rage to extradition, and the defense just dropped a bombshell. They're saying Louisiana already told this defendant to stay away from that parish with a permanent lifetime protective order. And now Louisiana wants him back to face charges? Legally speaking, that's a fascinating contradiction. Under the Uniform Criminal Extradition Act, a governor's warrant is usually bulletproof, but a conflicting court order? That's rare.
May 4th, 2026, and remitted it over to the Texas governor's office on May 27th, 2026, where our governor, Greg Abbott, has signed and accepted the governor's warrant. It is issued out from our Secretary of State, Nancy Nelson, to our sheriff's office on May 29th, 2026, and the defendant was served yesterday, which has been provided to a copy of this court on June 9th, 2026.
Mhm.
And so otherwise, the papers are in good order and the state has fulfilled their requirements under codified 5113 that doesn't have the Uniform Act for extradition.
Do you have any issues with the paperwork?
Yes, Judge, we do. And this is not outlined in the actual application for the writ of habeas, but there is one other issue regarding fugitive status. But I'll get into that one. The issue here, the main issue was the fact that the documents on their face are not in order. We have an actual affidavit from the detective that was involved in this case, saying that these actions were done on August 2024. Mr. Theriot has been living in Houston, Harris County, since May of 2016. He was actually served with a restraining order, a criminal order of protection, and it actually includes that it's permanent lifetime. He was actually ordered to remain in Katy, Texas with his father. This is an order that was brought down by the same parish that is now requesting that he come back, even though there's an order contradicting this because they had previously been told, he had previously been told to stay away. He has a permanent lifetime order in place in case number 7543-16 out of the 14th.
So you're saying there was a lifetime protective order? That was it?
Judge.
Okay.
Yes, and this was signed on this was filed on January 12th of 2017. All these incidents, even if we were to agree that all of them occurred on March, June, and October of 2022, and I'm aware that there's a carve-out exception under Section 6 of the Uniform Extradition Act that accounts for cyber-stalking crimes or crimes that can be remotely committed, right?
Right. I mean, that's.
Right, and I understand that part, but I also understand that he has been given two contradicting orders. One order restricts him from going near that property and from stay and to stay here. This is a permanent lifetime order, and as far as I know, it has not been revoked, it has not been overturned. No other judge has said, yeah, he can freely come back to Calcasieu Parish. So Mr. Theriot has been complying with that order since about 2016. And as such, he's not willing to return back voluntarily to the state of Louisiana in direct violation of this order as well. Yes.
But does that have any issue with, on its face, and the fact that the extradition documents are not in order?
Well, the main contention as far as the documents not being in order are the fact that there's a discrepancy in like a 2-year gap date, where the individual involved in this case has one previous affidavit that they used to secure a warrant that says that these acts happened on October 25th of 2022, whereas the new affidavit that was signed by that same individual on April 1st of 2026, he's alleging that these acts happened in 2024. That's a full 2-year discrepancy. If it were like a matter of days, I understand the leeway that is given with the honor about language, but I think that.
Sure, but I think that that's something that's handled over there.
As the court knows, for 5113 for the receiving state is that they are required to have 2 affidavits from sworn statements. The first one the council is referring to is the initial arrest warrant that was signed by the 14th District Court.
Sure.
The second one is an affidavit signing and attesting to the governor's warrant. And so that's.
Okay, so. I'm going to grant the governor's request and I'm going to order you to return back to Calcasieu Parish. You will be held at no bond while this process is going on. I would imagine within the next just couple of days, you'll be back to Calcasieu Parish. And at that point, you can deal with them and issues of bond and whether they'll, grant you another bond. But at this point, we're going to order you to return back. Do you have any questions?
Just the governor's warrant states that I was physically present in Louisiana to commit the acts. Is that, even if they're not on the.
I haven't seen it.
And that is correct, Judge. I believe an affidavit prepared by Jacob Johnson, part of the governor's order packet, clearly states that Mr.
And there it is. Judge Fleischer grants the governor's warrant. From a legal perspective, this was almost inevitable. Once a governor's warrant is introduced and appears regular on its face, the burden shifts hard to the defendant. The judge's job here isn't to decide guilt. It's only to answer two questions. Are you the right person? And are the documents in order? The protective order contradiction? That's a problem for Louisiana courts, not Texas. But here's what's wild, no bond. That means he's sitting in custody until Louisiana picks him up.
Variot was physically present in the year like 2022 to commit these offenses, physically present in the state.
I wouldn't know. I
I
don't,
have a witness who can testify that I was at the house.
well, that's something that you'll have to take up when you get back over there. This here, we're only trying to determine, are you the right person that should be charged with this offense? And whether there's enough to send you back to Louisiana to answer those charges. That's what my concern is identity. Are you who they say you are? Are the documents in order? If they are, at that point, we'll send you back and then you answer the charges over there and then you can make those arguments over there.
What about the fourth prong review, the status as a fugitive? That I fled the state and that I'd be entitled to the governor's discretion and not a mandatory.
It's just
Extra.
whether you are a fugitive. That's just the last
Your
prong.
Honor, we addressed this earlier, is that there's a carve out under section 6, is that there are exceptions in what we colloquially call 2B warrants, that they are recognized by both governors of Texas and Louisiana as qualifying for 5113.
They do, 2B warrants are issued all the time, you know? Yeah, so, all right.
All right.
So, Your Honor, just for the record, in accepting the governor's warrant, state would like to introduce Exhibit A for the governor's warrant and the service, and as a court formally denying the writ for the defendant.
Yeah. All right. Oh, do you have any objection to the admission?
The admission would be the original governor's order packet that we will
With the
provide.
service slip.
Yeah.
Yeah, no objection to this.
Okay. It'll be admitted and the writ will be denied.
Can I appeal the denial of the writ?
Sure. Yeah, and she'll go over that with you, but I'm going to grant the writ. I mean, not grant the writ, I'll deny the writ.
Yes, Your Honor.
Okay,
Thank
thanks,
May
guys.
we be excused, John?
Yes,
We have the record.
off the record.
Oh, right.
Thank
So-
you, Ramon.
Is it top of 34?
Yes, sir.
Is he here?
Yes, sir.
Yeah, we need to do PC.
Yes.
Yeah, we need to do PC.
And
Deonte Smart, come up.
I would like to kind of hold off on it so I can look at the discovery a little bit. There's two.
Well, I get it, but I still have to do PC on it. I can't not.
Okay. Now, if I recall, you do allow us to reapproach up to you.
Sure, of course.
Okay.
Yeah, absolutely.
Perfect.
Anytime.
I'm signed to only case, but I have not had a chance to do it.
All right, you are Mr. Smart. Sir, you're charged with unlawful carrying of weapon and displaying a fictitious license plate.
The fictitious plate is already condemned. He's reached to Wednesday. June or July.
July.
Oh, he picked up a new case. Oh,
And that's why
Oh.
the PC is a little more interesting.
we are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
On June 6, 2026, in Harris County, Texas, officer observed a vehicle traveling with an expired license plate. Our traffic stop was conducted. The defendant was the front right passenger, but also the registered owner of the vehicle and stated he is the owner. Officer observed strong odor of marijuana from inside the vehicle. Officer observed the front of defendant's shirt to have 9 pieces of marijuana on it. Defendant admitted to smoking marijuana earlier and also admitted to being in possession of a handgun inside the vehicle. Defendant stated everything in the vehicle belonged to him. Officer located inside the vehicle a plastic pouch of marijuana as well as a handgun on the front right floorboard of the vehicle.
Mr. Smart, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. You will be tested 40 days from today. If you test positive for dope or alcohol, I will revoke your bond and put you in jail. Do you understand? The one thing I told you not to do was pick up a new case, and you picked up a new case. What happens now? What happens now? No, you're going to jail today. I don't ask much from you. Don't pick up a new case. And if I find that you have a weapon again, it's just going to keep going higher and higher. You understand? Okay.
He's got, he made a.
I'm not going to touch the new case, but I'm going to revoke it just on the old one,
So I can tell his family what's the.
5001.
For the fictitious plate. We should consider 2500. And let me.
State, what do you say?
We defer to you, Judge.
All right, I'll set it at 2501, but I'm going to tell you now, you will get tested 40 days.
From complex extradition law to swift jail time, this is Judge Fleischer at his most direct. Here's what just happened. Mr. Smart was out on bond with two very simple conditions: don't do drugs and don't pick up a new case. He did both. And the judge's response? Revoke the bond, jail today, and he's not even touching the new case yet. Legally, this is a textbook bond revocation hearing. Probable cause was found for the new offense, marijuana plus handgun, and that's enough. No jury, no trial, just consequences. Here's the reality check. In bond revocation, the judge doesn't need proof beyond reasonable doubt. Only preponderance of evidence.
Days from today, and I'm not going to play this game with you. Do you understand? Okay, all right. Hi, are you ready? Are they bringing him out? No. Sebastian, I signed your motion. Is that what you want?
Yes.
Yeah, I got it. And then for future reference, just, you don't have to stay. Just put it up here and then.
I'm waiting for the surveillance thing.
Oh, got it. Well, then you can always Zoom. You don't have to
I'm gonna
stay.
be here anyway.
I told him I could email him and contact him.
I'm going to
I
here.
just
I love being in this place.
Yeah.
investigator did go out there and try to get it.
Okay.
We can do it every 12%.
We email and then someone's gonna come help us out, but yeah.
Because I have the one with the ankle monitor.
So forget right. Hey, Syed, what's up, man? Great to see you. What's new?
Dude, I just had some interns with me. I'll take them around, introducing the judges.
Yeah,
Whenever you have a
just
session.
let me do this plea real
Yeah,
quick
no problem.
and then we'll, because I don't want them to come up and then they
Yeah, no, I got it.
security risk.
I want to walk the plea anyway, so.
Yeah. So no dice on Porter, huh? Okay. Yeah.
You just have this first, the conditions, or you want me to have them sign first?
Yeah, I can sign it. If you wanna,
I just followed him, Judge.
okay, I'll sign it, then we'll print it out and we'll give you a copy. Yeah, for sure. So you're gonna have to give me a couple minutes for it to pop in.
Yeah, pop up across the hall.
Okay, sure. I've got Dan Corrigan also here. He's got 3 cases that. So he still has the case upstairs going on, right?
He plans this case.
Oh, really? Wow. He just got filed.
Yeah.
Right.
He got probation.
Wow, that was quick.
Mhm.
All right, Mr. Wessels, good morning, sir. Sir, you're charged with driving while intoxicated, second offense. You're also charged with possession of a dangerous drug. On both of those, you're facing up to a year in jail and or a $4,000 fine. It looks like you have worked out an agreement where they're offering you 9 days in jail with credit for the 3 days that you've done. It looks like it's a reduction to a first. You know how many people we have in TDC doing life on a DWI? This is now 2 with us, a second, and now you have a DWI upstairs. What's it gonna take for you to get the message? Serious prison time? You and all your 100-pound, you know what they would do to you in our Texas prison? Do you have any clue what they would do to you in prison, Mr. Wessels? Take a guess. I've read stuff and it had me in tears because of the way that some people are treated in our Texas prisons. It's freaking disgusting. You are now facing up to 10 years in prison. If you have a problem with drugs or alcohol, it's probably a good time for you to address it because really, the agreement that you've worked out is 9 days in jail, credit for the 3 days that you've done. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers if you are not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you accept this agreement. You can never change this or undo this. You understand? Every time you pick up a DWI now, you will be facing serious prison time. How do you plead to this offense? Guilty or not guilty?
Good.
I'm going to find you guilty. I'm going to follow this agreement, sentence you to it. I'm going to suspend your license for 1 year. Do not drive until you get a license. Stop getting into a car. Don't drive. You and cars do not mix well. Do you understand? If you want to get lit, take an Uber. $30. It's a geographical oddity. Wherever you want to go in this life, you take an Uber, always $30. Good luck, sir. Thank you.
And this right here is why Judge Fleischer has millions of views. This is a DWI second offense. The defendant worked out a deal, 9 days in jail, credit for 3 served. The judge accepts the plea, but then delivers one of the most memorable judicial lectures you'll ever hear. You and cars do not mix well. If you want to get lit, take an Uber, $30. It's a geographical oddity. From a legal standpoint, the judge is absolutely right. In Texas, a second DWI can already bring up to a year in jail. A third, that's a felony, 2 to 10 years in prison.
Ready?
Yeah. These are our 3 environmental interns for the summer, Judge.
Nice to meet you guys. How's it going?
I think some of them have already heard about you, seen about you.
So what are you guys in law school now or are you undergrad?
Law school, just completed 1 L.
Nice. Go to law school. It's so much, well, no, I was going to say it's fun, but it's not fun. It sucks. But I tell you, I mean, you really, this life, it's about knowledge, right? The more you know, the more just life is better for you. No one can take you for a ride, you know, and really when you're a lawyer, it just, there's no greater profession in this world. It's hard, but it's worth it at the end. You know, if you put your heart, soul into it, if I can become a lawyer, freaking anybody can be a lawyer. Really, it's just how much heart you have, you know? You're welcome to come anytime. You guys want to hang out with us. Fridays and Mondays are our busiest and it's a lot of fun around here. But yeah, you're welcome to hang out anytime. And I would go and watch as many trials as you can. You need to see the best. We have so many great lawyers in this building. The more you watch, the more you learn and the more you kind of sponge off them, develop your own style. But really, just the world, your oyster, anything you want this life, the harder you work, the more passion you put into it, really.
Thank you.
Yeah, absolutely. Come by anytime and just hang out. We're happy to have you.